Welcome to the June 26th, 2014 edition of Franchise Focus. I am Rick Bizio, the author of The Educated Franchisee, and I'm your host this evening. For those of you who have listened to our show previously, you know that this Franchise Focus is dedicated to sharing a wide variety of information and relevant information regarding franchising and business ownership. Today is the second part of a two-part series focused on really one of the most important documents in all of franchising, the Franchise Disclosure Document, also known as the FDD. Last month, we mentioned the fact that the FDD is a large, often 250-page plus document that every franchisor must by law have, and they must disclose it to prospective franchisees at least 2 weeks prior to signing the franchise agreement or upon reasonable request. It's a document that can be intimidating. It's a lot of pages, a lot of information in there. Our goal is to try to help you better understand the structure of the FDD, the purpose of the FDD, and by doing this, helping you save a lot of time in regard to identifying areas where you need to focus your attention when looking at an FDD. Today, I'm happy to announce that Nancy Lanard, senior attorney at Spadia, Lanard & Leana, is back with us. Ms. Lanard is really one of the most respected franchise attorneys in the United States, and she spends a good portion of her practice working with prospective franchisees, reviewing FDDs, and helping them better understand the nature of the franchise relationship. Again, as I mentioned, today's call with Ms. Lanard will be a continuation of last month's podcast. So before I jump into a more complete introduction of Ms. Lanard, let me just kind of do a little bit of housekeeping for those who may be listening. Should you have questions, want to call in and ask your question directly to Ms. Lanard, the direct phone number here is 718-766-4221. Again, that's 718-766-4221. If you're looking for more information on Educated Franchisee, you can find us on Facebook at The Educated Franchisee, Twitter at EducatedZ. Our websites, educatedfranchisee.com, fddexchange.com, franchiseglossary.com, and afranchisecoach.com. And our books include The Educated Franchisee, The Franchisee Workbook, and a glossary of franchise terms. Just an abbreviated bio for Ms. Lanard, because it is such an impressive bio, but she's been nationally recognized for really over 20 years as being one of the top franchise and business attorneys. She's received many prestigious awards, including the Legal Eagle Award by Franchise Times. She's one of the leading franchise publications out there. Ms. Lanard is a results-oriented attorney, and she works diligently to help individuals achieve their goals. Whether you're looking for an attorney just to evaluate a franchise document in which you're looking at potentially investing into, or you're an existing franchisee and you need some advice in regard to negotiating a lease or working out a situation, Nancy's clients come to her really for legal services, but they stay with her because of the confidence that she's able to give them as she guides them through various processes. So should you at the beginning wish to reach out to Nancy directly, the contact information would be Nancy Lanard. The phone number is 215-525-1165. Her extension is 101. And the website is spadialaw.com. It's SPADEALAW.com. So let me see if I can get Nancy on the line here. Do that there, and Nancy, are you there yet?
I am here, and thank you so much for that lovely introduction.
Oh, you're welcome. I'm just really happy that you're willing to give us another hour of your time.
It's my pleasure. This is fun.
Yeah, well, thank you very much. Last month during this podcast, we discussed, the history and purpose of the FDD. We also discussed the franchise rule and registration states and waiting periods, and we also focused a lot on items 1 through 6 in the FDD, and we talked a little bit about item 7. So As we start today's podcast, it seems logical that we'd start on item 7. However, you and I spoke just a little bit previously before starting the podcast, and item 3 that we discussed last week has to do with litigation. And there were a couple things we talked about, and you felt like you wanted to add a little bit of clarification to that particular topic. So maybe we'll just start out with item 3 and then jump back to item 7. Would that work for you?
That works perfectly. Yeah, I wanted to clarify that with item 3, which is the litigation disclosure, a franchisor must disclose anything that's pending or actively going on in the disclosure document, but also there are certain types of other disclosures for litigation that must occur. For example, litigation that's against the franchisee. It's very specific as to the type of litigation, and there's even some disclosures that you have to go back to prior actions as far back as 10 years. So I just wanted to take a second to just mention that, and that's it. I just wanted to clarify what I had said previously and make it a little bit clearer. But yeah, we can pick up on item 7 if you want and start going through it. I think that's a really critical item for any prospective franchisee to understand what it's going to cost them. I mean, that's a question I get every time somebody calls me looking to invest in a franchise. Ultimately, what is this going to really cost them, and are they going to be able to afford it? And, of course, the next question, which isn't answered in 7, is, at what point am I going to be able to make that back, be making a profit and get back that money?
Well, let's start with a really basic question. I mean, item 7, of course, is the estimated initial investment. That's the title, and it includes all the costs you would potentially need. It gives you, in order to get into the business, gives you a high number and a low number. Let's start out with a basic question is, first of all, can the prospective franchisee, on average, generally speaking, can they trust this information, or is the devil in the details?
That just in the last few days, your question's really timely. I had a client of mine. We reviewed the franchise documents with them. They actually a couple of years ago, and unfortunately, they took a long time to find the right location. They're in a very, very expensive market. And the estimates which they relied upon are extraordinarily off by multiples of what it's in reality going to cost them for things such as leasehold improvements and even equipment, which is being bought through the franchisor, is 2.5 times what the item 7 chart had disclosed. But leasehold improvements, because they are in franchisees, not prospective anymore, is in the New York metropolitan area, and so that's obviously a very costly area. Cost of living is very pricey there, so it's just costing tremendously more than what the item 7 chart had indicated. I think in general, one is supposed to be able to rely upon it as estimates. And it's always told in terms of a range. Item 7 includes things such as equipment costs, leasehold improvements, the franchise fee itself, and legal fees, and any training expenses, working capital, marketing fund expenses, marketing expenses, and so forth. But the devil's in the details, and the details are in the footnotes. And so I always tell my clients, first of all, it's told in terms of a range, and no matter where you live in the country, you should always budget on the high end of the range, because in my experience of doing this for quite a long time, those franchisees who don't make it are the ones who are undercapitalized more often than not. And so having sufficient funds when you start out with the business is, to me, a critical thing to make sure that you have. That high end of the range, item 7, I think it's very important that everyone understand, is only there to take you through an estimate of what it's likely to cost to open up the business and to get you through the first few months of operating the business. Since most businesses are not in the black that quickly, you obviously need to multiply that number by some amount of time that it's going to take you to be in the black. So if it takes 12 months to be in the black and this only takes you through 3 months, then you're going to have to multiply that figure by 4 times that. And most people are shocked when I say that. but it's a reality that most businesses, there are some businesses out there, there are some franchises out there that certainly you can be in the black very quickly, but the majority, that's not the case. And unfortunately, with this client that called me recently, he's finding these expenses to be so many more times higher than what was ever budgeted, and he's now in a quandary. He really can't afford to continue to move forward, and he can't afford to lose all the money that he's put out to this point. So he's in a tough position.
I've seen that situation happen, especially in the New York area. When you get a piece of real estate, you look at this high number, low number, and they talk about deposits, and they talk about leasehold improvements, especially if it's a storefront. I mean, if it's not a storefront, then this isn't really as applicable in regard to a discussion. But in the case of a storefront, you have a lot of those costs that many times landlords will pick up for you in many marketplaces, but in northern New Jersey, they just are less likely to do it, it appears. And so you end up with a lot of those costs, and you are right. I guess that deposit, not deposit, the cash flow requirement, it has to be at least 3 months, but they could include up to 6 months or longer if they wanted to, but often fail to. Often they put it about 3 months.
Most franchisors don't include in the requirement, and there's even some question, in the guidelines of whether you really can include more than the 3 months. It's a tricky thing because the federal law says Item 7 is to disclose what it takes to open and in the first few months. And if you disclose 6 months, sometimes that constitutes an error. So you would think more disclosure would be desirable, that the federal government and the states that regulate franchising would certainly encourage greater disclosure, but sometimes they don't because they feel that can be misleading when you're analyzing. And most franchisors are not going to be too happy to disclose more than 3 months anyway, because obviously that means it's a higher number, and that discourages people from investing. So it's kind of a catch-22.
Yeah, I think the main message here is that the amount of what it costs you to get into a business will be affected by where you live. And if you live in Omaha, it's going to cost you less than if you live in Manhattan. And you definitely got to take all that into account. And when you talk to franchisees, really try to sort that out and figure out what the real numbers would be in your particular situation. And those notes, as you said, are very important, aren't they? It really gives you all the information.
Oh, they're critical because there's so much valuable information in those footnotes, and almost every disclosure on the chart is going to have a footnote with it that explains in more detail exactly what that includes, what it doesn't include, and how that number is derived. And so, yes, it's very, very important.
As an attorney, are there any specific red flags that you look for in this section? Could you look at one of these things and just immediately snap your fingers and say that's a problem?
No. I mean, I think the issue is how it relates to a particular franchisee, because honestly, the franchisee looking at it that's budgeting for a brick-and-mortar franchise, and as you said, that's really where this matters more. Obviously, a home-based franchise is not going to have the same overhead to get into, to open up and to get into it. And although there still is only the first few months of disclosure there in Item 7, presumably, you don't have the overhead. So that number is not going to be as critical as to what it's going to cost you to get started and get going. It just may be that you're not going to be making money for a while, but you're not going to have the expenses of rent and so forth. As far as the brick-and-mortar franchises and looking at Item 7, when they come to me and they say, I'm borrowing this amount from my retirement funds or an SBA loan or putting another mortgage on my house, and they tell me these things and they say, we're budgeting for, the Item 7 shows a range of $150,000 to $250,000, and I'm budgeting at $200,000. I say, well, even if they're in Omaha, Nebraska, in my eyes, that's a red flag to that particular individual. I always say budget on the high end, and if you're not able to afford that high end, then maybe this isn't the right opportunity for you, because budgeting on the high end, again, only will take you through those first few months, and that's just not sufficient to be in the black, and let alone pay yourself a salary. and have money that you're taking out of the business to pay your own personal expenses. And I don't think people realize that.
Well, I think it's something that has to be thought through very carefully to make sure that you're covering all your bases and that you're not stretching yourself so thin that it's a mistake to get into it. Absolutely.
Yeah, and when they're working with a great franchise consultant like you, then I'm sure that's explained to them, but many are not. And that's part of the problem. They come to me with without their eyes being opened as to really what's realistic.
Yeah, I tell you what, I mean, if when I work with folks, if they're anywhere close to being tight, I mean, taking all your net worth, all your ability, and rolling it on one location, it just seems foolhardy. It seems like you need to be in a certain situation where you're able to take a certain amount of your capital, a certain amount of your ability, and you are able to invest it in something that can work, but at the same time not to have your back against the wall. If you have your back against the wall, you tend to make poor decisions, and that's never a good place to be. But that's off topic. Let's talk about item 8. Restrictions on sources and products of services. Restrictions on sources of products and services. Occasionally I'll run into a franchisor that requires that the franchisee buy all their products from a sister corporation that happens to be owned by the same group of folks. How do you feel about that?
Well, even when that's not the case, chances are there's a kickback going to the franchisor, even when it's a third party that's unrelated to the franchisor. In most cases, there's a kickback or some kind of favorable advantage to the franchisor beyond the fact of a product that they recognize as being a quality product or one that they want to have you deal with. So it's more often than not that's the case. And
don't they have to disclose
I think it's something that should be disclosed, but what's disclosed here is the requirement that you have to do that. Yes, you also have to disclose that there's some sort of, particularly most of the states require some sort of disclosure about what percentage or what amount in very specific terms is being kicked back to you or that you're getting advantages for your own corporate locations, franchisor centers to buy products at a discounted rate because of that and so forth. So yeah, I mean it is important to understand that this is not going to be necessarily competitive rates for the same product.
Yeah.
But yes, you have to disclose. You certainly have to disclose. The franchisor must be disclosing, whether there's any connection with any officer that of the franchise has an interest in the business that's supplying the products, and what the approval process is by the franchisor for granting new suppliers, and whether franchisees can bring new suppliers to the table, how approvals are made or not, or rejected. All of that has to be disclosed, whether there's certain standards and specifications for bringing new suppliers in, and also whether the franchisor or any of its affiliates are actually deriving any revenue or, any kind of consideration. So just as we were discussing, that has to be disclosed. Whether people actually read that, item 8, that carefully to see that, I certainly don't hear people asking me questions about it.
Interesting. I know back when I was in the restaurant sector with Popeyes and Churches and that sort of thing, we had 3 basic kinds of products. We had exclusive products, which were proprietary by nature, like the spices and that sort of thing. We had approved vendor type products that you had to buy from an approved vendor, such as poultry. Chicken had to be bought from one of the main 2 suppliers because we had national contracts and they had certain weights and cuts and so on and so forth. And then there was kind of open purchases. In other words, the purchase was defined, but you could purchase it from any place that had a competitive price. And I do know that back then we used to have specific language that said we do not receive any kickbacks. Specifically, we put that in the disclosure document back in the 1990s. I have no idea about now. But
now it's required that you definitely disclose any sort of revenue that is received from a supplier, an approved supplier.
Interesting. Well, again, it's important. And when you talk about it's like vending machine concepts, where you have to buy all your products from them and there's no royalties, then you really have to start scratching your head and being careful because you don't know what you're paying at that point. You don't know what your real royalty is.
No. Exactly.
You know?
You clearly are paying that royalty through the cost of the product.
Exactly. Anything else you want to mention on item 8?
No, it's just that it's an overlooked item, and it's just important for a franchisee to understand that they're going to be restricted. I think, again, looking at the naive franchisee, and many are when they come to us, that, they don't understand that this isn't really going to be training in the business, and then they're up and running and they can run it any way they want. There are a lot of restrictions, and it is almost like a parent-child relationship, and they have to understand that.
Yeah, absolutely. I look at it as being part of a condominium association.
Like that.
There's all these
good analysis.
There's all these rules, and everyone kind of has to live together, and what you do can affect your neighbors, and
Yep.
sometimes there's it's not always perfect, but if you work together, you can end up with a nice community. Let's talk about item 9, franchisees' obligations. This is something that I think a lot of prospective franchisees do look at, I find, as they tend to, what do I have to do? So what do you typically look for as an attorney? What do you look for in this section? What's important to you?
I just try to point out to the client that, when I'm representing a franchisee, that this is an important thing for them to review very carefully, again, looking at the footnotes as well, and understand that these obligations that they have to the franchisor, we tend to talk about it. I know we're going through the FDD, but when we're going through the franchise agreement, which is the client's contract, the franchisee's contract with the franchisor, that's where we're really focused, because, again, these are all restated in the contract as a contractual obligation. So I think it's very important that the franchisee understand that that's a contract, that they're signing a contract, they're bound for that period of time, if it's 5 years or 10 years or 20 years, that they're bound, and that these obligations that they have, that they've agreed to and signed on that contract, are a binding legal document that they can be sued on if they don't comply with. And so I think it's very important that they understand what these obligations are, what the time frame is that they have to comply with those obligations, and what that entails on their end that they have to do.
I haven't looked at as many FDDs as you have, obviously, but I've, over the course of a couple of decades, I've had a chance to look at quite a few of them. It appears to me that most of the obligation lists, most of the item 9s in the list of obligations are fairly similar from franchise to franchise, and they seem to be. There seems to be. There's a very much a norm in regard to what these expectations are. So I guess maybe you give a couple examples of the kind of obligations that are kind of normal and traditional in franchising, and maybe
I can go through the list. It's an actual list that the guidelines require, the federal guidelines require that a franchisor put in item 9, and so it starts with site selection and acquisition of the lease, and then pre-opening purchases and leases is B. C is site development and other pre-opening requirements. What this is a chart or a table, and it shows each of these lists of items, where it is in the agreement, the franchise agreement, which, as I said, is the contract, and which disclosure document item it refers back to. So there's a chart that shows these lists with each of the agreement sections in it and the disclosure sections. So going through that list, we were up to site development. Then there's the training. They have an obligation to go through training, what their obligations are on opening their business, fees, what their obligations regarding compliance with any standards and policies, for example, the operations manual, what their obligations are regarding trademarks and proprietary information. And most of those are okay. Those are things that most franchisees are comfortable with. Now we're getting into restrictions on the products and services offered. So there, the item in the disclosure would be obviously item 8 that we just talked about, and then whatever section in the agreement it refers back to. Warranties and customer service requirements, territorial development and sales quotas, and then it continues on. I think some of the issues that really are really to a franchisee or prospective franchisee to understand is what are the requirements if it's a brick and mortar to maintain it and remodel in the future. And typically, most franchise agreements require, for example, that if the franchisor requires remodeling, let's use the example that I did the last time where we talked about McDonald's, since everybody knows McDonald's. If you look around, the McDonald's around the countries are all being remodeled. They look a little different than they did certainly in the 50s, and they look a little different than they did in the 1970s, and they look a little different than they did even, 10, 15 years ago. And that's because there's a right in their agreements for McDonald's to say, this is how we want you to look now. It's, we want a fresher look. We want different colors. They just remodeled what Ronald McDonald looks like. So they changed his clothing, and they want the stores to reflect that. And so that can cost a lot of money, and I think that's something that it's very important for a prospective and an existing franchisee to understand, that a franchisor has that right to be able to require remodeling. They also can require a certain amount of advertising requirements, that you're required to do national advertising and put money into a national advertising fund, and maybe a local and a regional fund, and that there may be certain insurance requirements that you have, and requirements regarding staffing, and whether an owner is required to participate in actually running the business, or whether you can hire someone to run. All of that would be disclosed in Item 9.
Gotcha. Yeah, it's a long list,
also,
and it's very structured in that all franchisors have basically the same list. It's the standard.
They all have
way.
the same list because it's a standard requirement. Yeah,
exactly.
And even things such as are they allowed to compete at the end of the day, when another really critical issue that we talk about in the franchise agreement, that they are going to be under a non-compete. Almost every franchisor out there has a requirement that their franchisees enter into a non-compete, and even their family members do, for some period of time after the termination or expiration of the franchise agreement. And as a result, certainly that's an important thing for somebody entering into the franchise to understand. Again, it's not their own business per se, it is. But at the end of the day, if they don't renew the franchise, they can't continue the business, even under a different name. So
you can't
that's
take the system that they have.
That's a pretty important point.
Yeah, it's usually it's a 2-year non-compete, and it's usually geographic in the area that you were previously doing business in order to be enforceable. Usually, I think that's the way it's set up. But basically, I think what it's saying is you can't take the system that they've taught you, and then 5 years from now, basically say, I don't want to renew, and continue in competition with them, right? With the same knowledge that they just taught you. Which
exactly
seems fair to me. I don't know. I mean, but if you came in with your own knowledge, if you have run, let's say you've run a bunch of hotels previously, and you want to take one of your hotels and convert it to Sheraton, in that case, the non-compete really wouldn't happen, because you've already got a lifetime of experience. You're a seasoned hotelier, and they really wouldn't try to apply that non-compete in that situation. But in most situations, people are new to the sector, and they have to be taught, correct?
Well, it depends. I mean, I have a client this was several years ago, it might have been 10, 12 years ago, and she was a headhunter, recruiter, and she bought a recruiting franchise, and she ran it for a while. She and her husband, they were both had been recruiters prior to buying the franchise. They bought the franchise because they thought it would give them resources for clients that they didn't have previously. They did that for 5 years or whatever the period of the franchise was, and at the end of the day, they didn't want to renew, and they wanted to continue with their business. And I don't think it was fair to have a non-compete in that situation, but they were under one. We were able to negotiate something for them.
They did negotiate. I was going to say, did they discuss that with the franchisor prior to getting in? Because
we discussed it with the franchisor right up front, that they were, experienced already, that the training was in the franchisor's system, but not in actually being a recruiter. there's two sides to this. The franchisor has made an investment, like you said. The other side is so is the franchisee. And then when it's a brick and mortar, they've got a lease. They've established a market base. They've gone out and brought the brand recognition to the area where there might not have been brand recognition at all before. There really are two sides to this issue, and I think it is unfair in some ways to a franchisee to not be able to compete, and continue the business afterwards if they get rid of all the identification from the franchisor and continue to run it. And on the other side, I understand the franchisor's perspective that, why would you want to set up someone to just, at the end of the day, compete with you and not have to pay you royalties anymore, that you've trained and brought into the business. So I think that's really an issue with two sides to it.
Yeah, I think that if franchisors were by definition able to, if the franchising in general did not have a non-compete provision, if any franchisee could at any time terminate the agreement and go into competition, I think it would fundamentally change the landscape of franchising in many ways.
I agree with you. I happen to know that 20 years ago, most franchise agreements did not necessarily have non-competes in them. But today, I've never seen one that doesn't.
Interesting. Let's talk of item 10 is financing, which most franchisors don't offer in-house financing, and they say something to that extent, right? We don't offer indirect or direct financing, and we don't guarantee that you're financing or something. Now, if they do offer financing, of course, it would be listed here. But in most cases, they introduce you to third parties that would assist you with the financing, and they don't do it in-house. Is that kind of a fair summary of item 10?
Certainly my experience. Yeah, certainly my experience. Very infrequently will you ever see a franchisor that offers financing. But if they do, the disclosure here requires very specific things about what you have to disclose regarding that financing.
Absolutely. Just a quick break. This is Rick Bizio with Franchise Focus, and we're on the phone on the podcast today with Nancy Lanard of Spadia, Lanard & Liana, discussing FDDs. If you have a question and you'd like to call in, the number is 718-766-4221. Again, 718-766-4221. All right, let's talk about item 11. Item 11 is franchisors' assistance, advertising, computer systems, and training, which is kind of a mouthful. It used to be called franchisors' obligations. Why the name change in 2008?
Well, I think it's more specific. It is franchisors' obligations, and it's kind of the mirror of item 9, which is, franchisees' obligations. But this is more specific, and I think the rules changed to make it more specific as to what had to be disclosed in here and included. And this changed in 2007 and 8 when the FDD was created, as opposed to the old UFOC, which we talked about last month. So when that change happened and they made changes to the FDD, this was one of the changes. This is a huge item. There's a lot of meat to this. And again, I refer back to the franchise agreement because that's the contract, and what's disclosed in here should be consistent with what is required in the franchise agreement. Because I think it's really important, and sometimes people don't understand this, that the FDD and the items 1 through 23 that we're covering last month and this month, these are disclosure items. They're meant to educate a prospective franchisee before they enter into the contract. But the contract, the franchise agreement itself, is the legally binding contract or document that binds the two parties, the franchisor and the franchisee. And that is the four corners of that document is actually what you could go into court, or someone or the franchisor could go into court to enforce.
Absolutely. It's good to reiterate that. I know we talked about that last month, but it's important to mention that again. The FDD is not a legally binding document. It is a disclosure document. One of the addendums is the actual franchise agreement, the template franchise agreement. And a lot of the content in items 1 through 23 is derived from, not all of it, but a lot of it is derived from the franchise agreement itself. Is that fair to say? Probably half of it.
Absolutely. And I think I think it's very important to say that, and I think it's very important to understand that that document, that franchise agreement, in most cases today is something that can be somewhat negotiated, not heavily negotiated, but there typically are things that can be negotiated in it to protect the franchisee or to clarify items in the franchise agreement that may not be as clear. And I think that's, it's why it's critical to have it evaluated and have it evaluated by someone who is very familiar with franchise agreements and franchise documents, because a general business attorney is not going to know what to do with it, honestly.
Yeah, it's kind of like going to a what do you call it, a general practitioner if you've got a problem with your heart or your brain. You got to go to the right
exactly
doctor
like
for the right thing, right? So if you're going to be
Absolutely.
dealing with a franchise law, you need a franchise specialist. It's pretty simple.
Exactly.
So item 9 is franchisee's obligations, the big long list of obligations the franchisee has. Item 11 is a big long list of obligations that the franchisor has, and they're kind of the opposites, the yin and yang, you might say, of either side there.
They are, and they're not listed as neat and tidy in 11 as they are in 9. 9's really just a chart that references those other areas of the agreement or the disclosure document, the FDD. This is actually written out, and so it's a little bit different in how it's laid out, but it is the mirror of item 9 for sure.
Absolutely. Let's talk about item 12. Item 12 is territory. And territory is an interesting thing. Pretty much everybody I talk to, and as you know, I've worked with thousands of people over the years. Everybody comes to me and says, I want a big territory. Territory is really important. If they don't give me a big territory, I'm not interested. But when you really look at territory, some of the largest concepts in the United States today don't even offer exclusive territory, as well as many business-to-business concepts. It's more of a client-based exclusivity as opposed to territorial, or in some cases, it's an impact study guideline. So talk to me about territory and what this section does and what you should look for and what the give and takes are.
Yeah, territory is very critical in every way, because it's what it defines what you actually are going to be getting. And in many cases, territory, if it's a brick and mortar franchise, is just the store, and that's your territory. And I think what a franchisee or a prospective franchisee needs to be concerned about is, are they protected from the franchisor selling a franchise of the exact same concept literally across the street? And again, this applies predominantly to brick and mortar, but it also applies to even those that aren't, that are home-based, because are there territories that overlap so that somebody's out there selling, let's say, blinds out of their home to the same people? Are you advertising to the same groups of people so that you don't have any exclusive territory that you can call your own, that you can market and really promote and not waste that money at promoting somebody else's business? In a brick and mortar, there was a franchise, I'm not going to mention the name, but it was a fitness franchise, and they sold territories based on zip codes. And unfortunately, you could have a zip code on one side of the street and a different zip code across the street from that, and have two of these fitness centers competing with each other literally across the street in two different shopping centers. And that's exactly what happened. That franchise has had tremendous difficulties, and most of my clients that were against my better advice that entered into those franchises have failed, either closed their doors or sold their business for a tremendous loss. So I think territory is critical.
My experience is franchisors that don't have a thoughtful approach to how they're going to handle territorial exclusivity generally end up in trouble. They generally end up with unhappy franchisees. They end up with impact issues. It's critical that they have a thoughtful approach that actually makes sense. And we all know about the challenges. Every franchisor eventually wants to continue to grow, and every franchisee wants exclusivity for the entire state if they can get it, right? And it's always a middle ground of how much exclusivity do you really need to run your business. And I think that often moving towards impact study guidelines have been helpful as well. But there are also examples of non-storefront businesses that where not having exclusivity, I believe, is a great advantage.
It can be. It can be, like in a business coaching,
exactly.
In some of those type of business. Absolutely, you're absolutely right. So it really depends on the business. When I get a client that comes to me that's a startup franchisor client, I always recommend that they work with a consultant that can help them define such things such as the territory and what works best for their system and their model and what they're selling. So absolutely, I think it's critical on both sides of the coin. It can make or break both the franchisee and the franchisor. And I think it's important, with any franchise system, I think it's also important when we're talking about territories, two things. One, if it's brick and mortar, that the franchisors that have demographic studies done tend to be have really successful franchisees, because if they've done demographic studies and they understand exactly who it is that's their best customer, then they can locate the business in that demographic area that is going to be successful for that franchisee. So they tend to have more successful franchisees. And I believe very strongly in the brick and mortar franchises having demographic studies done so that they understand exactly who their customer is and where their customer base is located, so that they can locate and help give support in finding real estate. We're going back to the franchisor obligations. If real estate support is one of the things that they're obligated to do, that they understand the market and they understand where, based on those demographic studies, where the customers are and where they should be locating. And the other piece of it is if somebody is anxious to have a larger territory, often they're asked to sign an area development agreement. And what's really critical with that is the franchisor's desire is to have that developed really quickly. Unfortunately, usually that's too quickly, and the franchisee doesn't have time to develop each of the businesses before they're immediately looking for the next location and developing that. And it tends to be a fight, a battle kind of between the franchisor and the franchisee's needs. The franchisee needs to be able to have time to develop the business, which could take 12 months to 18 months, like we talked about, to be in the black, and really have the business up and running and have the market, the brand marketed sufficiently before they start having to open up the next location. And the franchisor, of course, wants to develop the territory quickly so that the brand is more developed and so that people are out there and have options. So it's a real pull, between the two.
Yeah, absolutely, and that is an area that is traditionally negotiated up front as to,
it is
franchisee wants more time, franchisor says, listen, I can only give you a certain amount of time, otherwise I got to let other people do it, and you go backwards and forwards till people find a place that they're mutually unhappy with.
Exactly. Exactly. No, exactly. So, yeah, if they're looking to develop 3 stores, and to do that in a matter of 18 months is obviously, to me, ludicrous.
That's not possible.
But from a franchisor perspective, to do that in 6 years might be crazy. So somewhere in between is a nice compromise.
Exactly. Item 13 is trademarks. How important is it that the franchisor have federally registered marks, word marks, as well as their logos? And
okay, well, that to me is the cornerstone of the franchise. So, a trademark is what you're buying. When you're buying into a franchise, you're buying the brand. And if it takes, here's the problem. A trademark takes anywhere from 9 to 12 months to get fully registered with the federal government, with the U.S. Patent and Trademark Office. They're getting a little bit better, so maybe the 9 months is probably more common these days. So assuming it takes 9 months, but a franchisor can start selling franchises before the registration has been finalized. So how much of a risk is that to the franchisee, to the prospective franchisee? I think it's a pretty big risk. I think, it's certainly something that has to be identified. In item 13, it is identified and should be identified. But I think it's a risk, because understand, if you're brick and mortar and you put a sign out the door and you're putting the sign out that you're, ABC this, and all of a sudden you can't be ABC this anymore because now that they realize that they can't register that mark and they have to change the name, that's a huge risk.
I ran into a franchise about 2 weeks ago that does not have their federally registered word marks in place, and they have known pre-existing uses, predating them by 10 years with the exact same name. That, to me, is a full
That's a serious problem.
That's a full stop in my mind.
Yeah.
So generally, trademarks is fairly nothing. You look at it, there's not much there usually, because the franchisor has been around, they've got their trademarks, you're good to go. But if it's not like that, then that's when you pay attention to it, right?
The first thing that we always do when we're representing a prospective franchisee is check the trademark with the U.S. Patent and Trademark Office's website, because I don't really care what Item 13 says, because you can tell me anything you want in the disclosures, and even though it's federally regulated, it's supposed to be a disclosure that is accurate. I want to verify that, because to me this is such a critical issue. Gotcha.
Item 14, patents, copyrights, proprietary information. Anything specific you want to mention on this one? It's not one I personally spend a lot of time on.
You do or you do not?
I do not. I don't really. I haven't really ever dived into this one too much.
I think if you were investing in a franchise that was a technology-based franchise where there might be a patent on it, there might be proprietary information, then it would be disclosed there. But the typical franchise does not have a disclosure there at all, or it has a very minimal disclosure. There might be some copyrighted materials that need to be used, but by and large, this is not a critical disclosure by any means.
And I think item 15 and 16 are similar to that. Item 15 is obligation to participate in the operation of the business. That basically is saying, do you have to be there full time or not? That's basically the fundamental message there. And usually the answer falls on one or the other side of that divide. Item 16 is restrictions on what you can sell, which in many ways is, I think, similar to your purchasing piece. It's just, you have to sell what's offered as part of the system.
Mm-hmm.
Am I oversimplifying that?
Well, it is related to the approved suppliers and so forth, but it also is a little bit beyond that, in that it says that, at any given McDonald's, for example, could you also sell balloons, or could you sell dolls, Ronald McDonald dolls, or so on. So how far could you expand what you can sell at the store or can sell as part of your franchise?
But generally, again, not particularly critical in most situations.
Not a big deal.
Item 17, though, renewal, termination, transfer, dispute resolution. To me, this is pretty heavy stuff. So
absolutely.
Maybe you want to start with how renewals work. We only have, I only have 14 minutes, which is not a lot, and I want to definitely get to item 19 and 20. So at the risk of oversimplifying, what's the most important stuff to look at on item 17?
Well, I think, again, it goes back to the franchise agreement, and I think the issue is renewal, and what are the obligations on renewal, what's the cost to renew, and what happens if you don't renew, which goes back to that non-compete. So, I think it's really critical to understand that if it's a 5-year franchise agreement term, that at the end of that 5 years, you're probably going to have to pay some kind of fee and sign the then current version of the franchise agreement, which could be very different than the version you signed 5 years earlier, could have different royalty payments and so forth, and that's really important for someone to understand. So that's the most important thing. And then as far as termination, I think it's just you have to understand that there are different types of termination depending on the type of default, and to read through the list, that it's very important to understand what is a default in the franchise, and that's where, again, a franchise attorney can help explain that based on what's in the franchise agreement as in terms of what are the defaults and what are the franchisor's rights on those defaults.
Yes, and dispute resolution usually falls into arbitration or mediation, and they almost always want to have it in the state of the headquarters of the franchise,
it's always
correct?
going to be. Yeah, absolutely. Yeah. Litigation, too. Anything that's brought is going to be brought in. And now there are certain state laws that don't allow that require that any litigation be brought in the state in which the franchisee is located. But by and large, the agreement itself will require it be brought into the location where the franchisor is. It can be overridden by, obviously, state law.
Absolutely.
Pennsylvania's bill that's pending right now would override that provision, for example.
Moving on. Item 18, I'm going to almost skip. It's public figures, and if they have a public figure and there's a relationship, they'll discuss it, but otherwise they're probably not going to have anything.
Pretty unusual. Exactly.
Yeah. Item 19, financial performance representation. This is an area that every prospective franchisee salivates over. What do you think of it?
Mm-hmm. Well, that's why it's put in there, but honestly, I think I tell the client to ignore it completely because I write them. I know that the amount of disclaimers and the way that they're calculated, that they really mean nothing. Well, they don't. They mean absolutely nothing to the specific franchisee or prospective franchisee that's looking at it, because the reality is where your location is, if it's a whether it's home-based or whether it's brick and mortar, where your location is going to make a huge difference, and how hard you work the business, how you work the business versus the others. Everybody's unique and different, and I think it's totally meaningless. It's like saying it's like saying the average grade at a high school, or let's use a public high school. The average grade is B minus. Does that mean you're going to have a B minus at that high school? No, of course not. It means how hard you have to work, and how hard you work, and how well you study, and how the teachers that you have, and what subjects you take. There's a lot of variables, and it's the same thing with this.
I think that also there's one other thing I'd just like to throw in there briefly, and that is that some FDDs have a summary of actual past performance of locations in a summary fashion, which is kind of what you're talking about. There are other FDDs I've noticed that actually have prospective P&Ls, prospective information of what they think might happen based on an assumptive situation. And I think that those are quite misleading in many cases, because it doesn't have to actually be connected to anything in reality. And I think it's very important to understand that there are some companies that are doing that now and need to be aware of that, I guess, would be the right way to put it.
They're allowed to do that. And that's, especially if they're startup and new, and it is, I think it is really problematic.
Yeah. Item 20. Outlets and franchisee information. This is important. So we've got, 5 tables. It used to be only 3 tables. They changed the format. I love the new format. I think the new format is much, much better than the previous one. You can actually understand it, and the numbers add up properly. What are your thoughts in regard to item 20?
I agree with you. I think it is an important one. I think you look at the charts, you have a good understanding. It's amazing how many people call me, to help them with reviewing the franchise documents and have never looked at this. I ask them how many franchisees are there in the system. They have no idea. Well, it's here. It's stated on the chart, so it's pretty clear. And I tell them, item 20 would tell you that. To me, one of the most important aspects of item 20, in addition to the facts, the charts, which are laid out very easy and readable and clear cut, but more importantly is the exhibits to item 20, because the exhibits to item 20 is a list of all of the franchisees that are in the system with their contact information, and an additional exhibit is a list of all of the franchisees that have left the system with their contact information. Now, that contact information is going to be their last known business contact, so it may or may not be valuable. But
it's hard to find those people sometimes.
The value of, pardon me?
I say it's hard sometimes to find those people.
Exactly. They're a lot tougher to find, but the value to me of item 20 is to have my clients go and call as many of those franchisees that are in the system and every one of the franchisees that have left the system that they can get a hold of. As far as the franchisees that are in the system, a decent percentage of those around the country is what I would recommend. And really have a list of questions that you have for those franchisees, such as, what do they like and dislike about the support and the training they've received, and do they feel that they're getting value for the royalty payments that they're making even after, several years in the system? And would they do this all over again if they could? How long did it take them to get into the black to be making a profit? All the kinds of questions that I think is important to have answered that are not part of the disclosure document, that should be answered before you make this investment. And I think this is the opportunity with this list, not getting the list from the franchisor of the franchisees that the franchisor wants you to call, but rather having a list of all of the franchisees so you can just randomly start calling around the country and seeing if they're happy campers. Because if you find a lot of franchisees that are unhappy, walk away.
Yeah, and actually in my book under, I think it's chapter 11, I believe it is, 11 or 12, I specifically, we talk about different kinds of franchisees to call, and one of those, of course, is just making random calls. But, it's interesting, I'll just share with you a little trick that I use to anyone who's listening, and that is that, and I have an FDD I just pulled up on my screen of a small franchisor that I'm not going to name, but just, that probably nobody's even heard of, right? In 2010, they had 22 locations. By the end of 2012, they had 79. So that really looks good on the surface when you look at those numbers. However, 2010, they had 22 locations. Over the next 3 years, they had, let's see, that would be 7, 12. They had 16 closures. Ceased operation, other reasons, 16.
Mm-hmm.
And you know that didn't happen when the one opened in 2012, right? So of the 22 that were in existence at the beginning of 2010, 16 are no longer there. So what they're doing is they're selling very, very fast. They're selling them faster than they're closing them, but it really doesn't indicate a good potential future for me because we have a fairly high failure rate based on a base, the base at the beginning of the time frame. So I don't know. It's a way I look at that.
I agree with you. I think that chart is very important. I think that there are franchise systems that hire sales forces that, again, I'm not going to name them. That there's 2 out there that are quite well known in the industry that they're not franchise consultants such as you, where you help to kind of do a matchmaking of an appropriate franchise with the knowledge of the business. These are sales forces that work for the franchisor directly, and they make their money based on getting a percentage, usually about 50% of the franchise fee and 50% of the ongoing royalties for life. So they're out there heavily selling to anybody that, can walk, basically, whether you qualify financially or not. And so many of these franchisees don't make it because they don't have the sufficient, this goes back to when we talked about item 7, they don't have sufficient financial resources to really be operating a successful franchise because this franchise is not financially the right one for them.
And it's our job to help people ask the right questions.
Mm-hmm. Absolutely. Absolutely.
Item 21 is financial statements. These is 3 years of audited financial statements for the franchisor organization. Obviously, you want to look at those. Probably hard to understand if you're not a CPA. So maybe have your CPA look at it. That might be a way to do it. And I guess the number one thing to focus on there, Nancy, I would assume, is just making sure that we have a company that is liquid, a company that's going to be there tomorrow that has a strong financial foundation to it. Is that fair to say?
I tell every one of my clients to have the audited financial statements evaluated by a good business accountant, preferably someone with even franchise background, who can evaluate item 20 and evaluate the financial statements and item 19, rather, the performance evaluation and the financial statements and help them understand those. So as well as other things, obviously, to help them set up the business and to understand the tax consequences of a corporation versus an LLC for their business entity, and just helping them set up the business with in a structurally, financially good way. So absolutely, I think it's another part of the team that should be a part of the process.
And that part of the team really should be on there. That the CPA really is a long-term member forever of your team because you'll be working with them on quarterly filings and everything else. But item 22 is the contracts, and usually you find those in the exhibits, including the franchise agreement. And item 23 is the receipt. Sometimes there's a misunderstanding among individuals. They think that by signing that you are in some way obligating yourself to anybody. Can you? It is just verify, if you could, very briefly, that the receipt does not obligate you to anything. It just simply records the fact you've received the document. Is that correct?
Yeah, it's
okay.
Just a paper trail that they have on file that shows that they've provided you with the FDD and the date it was provided, so that they have that for compliance with the federal and state laws that they have to comply with.
Nancy, we have so little time. I apologize. It's like I thought 2 hours would be plenty, and here we are at the end again. Talk to me. Take it just 2 minutes. Tell any listeners a little bit about what you do, how you help people. I apologize. We only have about 2 minutes, but hopefully we can kind of get a little bit in there.
Sure. Well, I love working with prospective franchisee clients, and what we do is we do exactly what we've been talking about today. We start by checking the trademark for the franchise they're looking at with the U.S. Patent and Trademark Office website. We check usually state records to make sure that the name of the franchise, the brand, isn't being used by another company that might have predated the registration of the trademark and therefore have some priority rights. We go through the FDD, we go through the franchise agreement, we go over everything with the client, make sure that they understand what they're entering into. We negotiate the franchise agreement on their behalf. We prepare an addendum to that as well, and we do everything on a flat fee basis. We also will set up their entity as a corporation or a limited liability company. We do all of this nationwide. And we get the advice from their accountant as to which, from a tax perspective, might be better. We talk to them about the liability issues and why they should be one or the other. And then we will set that up for them, again, on a flat fee basis. And third, if they're brick and mortar, we will also help them with the commercial lease, if it's a shopping center or an office building, for their business, and we do that nationwide as well. We're the recommended firm for many, many franchise systems for their franchisees for the lease reviews, and that's also on a flat fee basis.
Nancy, thank you so much. I apologize. We got about 30 seconds. I got to close it out. I really, really appreciate your time. Thank you so much. And
my pleasure. It's been a lot of fun.
Yeah, anybody who's listening, you can definitely reach out to Nancy. Her phone number is 215-525-1165, extension 101. I am on vacation next month. I will not be doing my podcast next month because I'll be out of town, which I'm very much looking forward to. We will get back after it in August with another episode. The guest is still to be determined. However, hopefully it'll be somebody very great, and have a wonderful summer. I look forward to doing this again with you at the end of August. Take care and have a great evening.